if you have a credit card and it's been charged off and now you've got the original creditor coming after you, or worse yet, a debt buyer coming after you, and by that I mean you've been served and now you've got a court date, this is what I want you to do. So first, don't ignore that type of notice. It can get you in huge trouble. We're talking potential to have a default judgment against you, and that would lead to wage garnishment. So we don't want that. If you need help answering this type of notice, go see the Linktree link, depending on which one of my social media sites you're seeing this on. That Linktree link is either going to be in my bio right underneath my account name, or I'm going to put it in comments so that you can click right on that link and then go to the third link from within there. That will take you to a debt lawsuit filing service. They charge a fraction of what attorneys would charge you on an hourly fee to help you with this. And the best part about that service is that they are attorneys. So do that. And then I want you to do this next. Next thing I want you to do is grab a copy of your credit card agreement. And if you don't have this, Google it. It will pop up. Then I want you to look to see if yours has an arbitration clause. If it has an arbitration clause, let me tell you, that is a powerful little clause there. And here's why. If you have that arbitration clause, then the original creditor or the debt collector or debt buyer, they are not supposed to be taking you to court. They're supposed to be going through arbitration for this matter. But there's a reason that they don't like doing arbitration, and I'm going to tell you why. Arbitration costs them money, and I'm not talking about a couple $100s. It can cost up to $4,000 or more for them to go through the arbitration process. They end up paying most, if not all, of your arbitration fees. And so it's not to their advantage to go through arbitration, when you owe, especially if you owe and they're coming after you legally for like $500 or $1,000 or less than $4,000. But that's why they don't like doing the arbitration, because they have to pay out of pocket. So if you are having to go to court because you've been served, you can ask the judge to allow you to take it to arbitration. And I'm pretty sure that that original creditor or that debt collector or debt buyer is going to ask for a continuation because they know better. And if you have this arbitration clause in your agreement, there's going to be information in there pertaining to how to initiate this process, as well as the organizations that you can actually contact them via the phone to get more information and start educating yourself on arbitration. So just make sure you have your agreement, go over it, make sure you understand what it says, and exercise your rights, and continue to follow me to learn more about credit.